morning, everyone. I think this is the wonderful IC designed by our chief instructor, Dr. Viral Shah. Unfortunately, most of the delegates, they have left. And those who are there, probably one of the response I heard from my colleague, they are frightened. They are afraid of these medical legal aspects. Why to go in deep? Why to read? Why to study? Why to learn more? But then that is not the correct aspect. You must know about the problems in medical legal aspects, because someone may face that particular trouble any point of time. You never know what's going to happen. The topic allotted to me is Consumer Protection Act 2019. What's new for the practicing ophthalmologist? Dear colleagues, this unfortunate Consumer Protection Act started in my own city of Pune in Maharashtra in 1986 by Grahak Panchayat. Those days they tried even medical profession under that Consumer Protection Act. And then after 10 years, it was finalized for medical fraternity. After that, it was revised into 2019. And the rumor was there amongst medical fraternity that we are happy that we are not under the purview of Consumer Protection Act 2019. But dear friends, that is not correct. Because there is an exclusion list by the court. And in that exclusion list, doctors and medical fraternity are not written. Unless it is written in the exclusion list, we are under purview of CPA 2019. Remember this. So remove this confusion from your mind. And what new things are added there? What are the real changes in 2019? Whether they are favorable for us or against us. This slide is very important. There are few things added. The first important thing, what I said just now, that medical fraternity, whether it's there or not, at present, till this point of time, yes, we are under CPA 2019. Next important thing is compensation amount is increased. Like what it was there in lakhs in the past has gone to crores. But little bit better thing for us, it is related to bills. What bills we are charging as ophthalmologists, and not only ophthalmologists, but for other fraternities of medicine, the bill most of the times doesn't go beyond 50 lakhs. So, if it is related to the bills, probably much more compensation shouldn't be asked for. That is the thing. Next important thing, which is worst from our point of view, is jurisdiction anywhere in India. Suppose you are practicing in the city of Mumbai and the patient coming to you having his address or her address in Haryana. And the complaint in the past was supposed to be lodged in Mumbai only, Maharashtra only. Nowadays, the place where the patient and relatives they reside, they can lodge the complaint in their own city, in their own state. That is the worst thing. Next addition thing is, it can be online application. Very easily available and accessible from everybody's point of view. So danger is, it is easily accessible for patients and relatives, so they can be tempted to make complaints against medical fraternity. Next important thing is, whenever the case is going on in consumer forum, there is provision of consumer mediation cells. This particular provision is not good, not bad that way. Sometimes the out-of-court settlement has been promoted by these bodies, that is mediation cells. And even if you haven't done anything wrong, you are tempted, you are asked to do the settlement. And that way these mediation cells are working. They are blackmailing the medical fraternity also for out-of-court settlement. Even the indemnity insurance companies are saying, why to go ahead? Even if you are not wrong, they are asking you, promoting you, motivating you to do out-of-court settlements, and that is about mediation cells. Doctor-patient relationship, what we have been talking about since years together. In the past, it was really good because medical fraternity was treated as profession. And after this Consumer Protection Act, it comes under business. So doctors are treated as sellers. About patients, they were clients in the past because we were professionals. We were treated as professionals. Nowadays, because the definition has changed, they are now consumers, they are buyers. And what has happened because of that? They are thinking, government and all, that it is pro-patient. So patients and society will be benefited at last. That's what they thought in their minds. But no, it is anti-doctor. And that is the worst thing for medical profession and doctors. But what has happened because of that? Even patients are receiving bad taste of it. Because what was there in the past, 25 years ago, 35 years ago, doctors, they were taking the risk, they were taking the chances of treating even the serious patients. And most of the times, the results were good. But even if the result is bad, they were not blamed because they had that confidence about patients and relatives and society. But nowadays, nobody is trying to take those chances for that patient who is having complications. That risk they are keeping in mind, and maybe some sort of defensive practice which is called. For medical legal protection, what medical fraternity has been doing just to protect themselves, some investigations are being done, CT, MRI. Probably because in the court of law it is asked, what precaution have you taken? Have you investigated the patient properly before telling this particular line of treatment? Second opinion is asked for, because sometimes you may feel, why to take the chance? Send the patient to another hospital, secondary or tertiary, ask them to have their second opinion. And what I said is the defensive practice. Like in the past, they used to dare to treat the patients. And nowadays, what you say, you are sending the patient to a higher center. Why to take the chance? Why to take the risk? Like in ophthalmology, suppose the accident patient comes, corneal suturing, perforating injuries, no chance. Suspicion of endophthalmitis, panophthalmitis, no chance. Send the patient to government hospital or higher center. So this is defensive practice. So it was faith in the past towards medical profession. What's that? Today and tomorrow, it is a suspicion. Medical fraternity is looked at with suspicion by the community, by the general people. And that is the worst thing. And hence, both are affected. Doctors' medical fraternity as well as patients and general community. Doctors are answerable surely to so many things like medical council, it is state medical council and national medical commission nowadays, civil courts, criminal courts. Just now we are talking about this consumer redressal, Janata Darbar, all simultaneously or sequentially. So CPA is a special law of civil nature with the aim of social welfare to protect consumers with the following features. No court fee. So now it's up to 5,000. Simple procedure of filing, hearing, decoding, etc. Summary trial is there. Speedy redressal. Then non-judicial members on the forum. One has to be the female. Not a court, but has a full force of it, that is QC judicial. Majority opinion is the order of the forum. Act is compensatory and not preventive or punitive. Then applies to all paid goods and services, but only free services covered are medical. Should I continue or stop here?
You can continue, sir. We can cover.
So jurisdiction, you know, district forum, state commission and national. So for district, it was less than 20 lakhs. Now it is 1 crore. For state commission, it was up to 1 crore. Now it has gone to 10 crores. About national, it has gone from 1 crore to more than 10 crores. And in the procedure, so summary procedure, complainant in 4 to 6 copies, complaint has to be there in 4 to 6 copies, affidavit has to be made, prefer to, and the thing is refer to the opposite party, reply in 30 days, that can be extended up to 15 days more. Hearing by president and at least one member in the forum. Lawyer is not mandatory. Evidence of affidavit, expert, book references and everything. Order to be signed by president and one more member. An ex-party decision can be given. So appeal system, everybody knows, district, state, national commission and Supreme Court. So these are the some proposed changes we already talked about. Thank you so much all of you for the pleasant, happy and safe practice.
Thank you so much, Marathe sir. That was really needed because there was a lot of confusion between this new Consumer Protection Act 2091 that the government has passed, and much confusion was there whether the doctors are under its purview or not. But recently also the High Court has given a decision, Delhi Court, that doctors are liable in this CPA 2019. So yes, we all doctors and ophthalmologists are liable under this CPA 2019, and we should tailor our practice